Well, good Monday morning. I'm Neil Gordon. Thanks for staying up. Welcome to Law Call. Tonight, answers to your legal questions. Here is what's coming up on our program. In our caller segment, we'll discuss how you can fight the insurance company if you've got a claim that just hasn't been resolved. What can you do? Well, if you have a question, we invite you to call us right now. The phone line's open at 803-442-4551. Now, a bit later in the show, we're going to talk about when to file a lawsuit. But first, Attorney Vic Hawk is here to take a look at one of your email questions. And how are you, sir?
Doing fine. How you doing there?
Good. Recovering from a little knee surgery.
Yeah.
All right.
No problem.
We're gonna give the insurance companies a pain tonight, I suppose. But before we get to that, our email question actually coming from Maggie, who got sick after eating at a buffet-style restaurant. Now, Maggie was off from work for 2 days, Vic, and she just wants to know if she can force her company to pay her for her time off.
Maggie, the answer to your question is real simple. Yes, you would have a claim against the restaurant. The problem with these kinds of claims is unless you have any permanent disability or a significant injury arising from it, it's going to cost you too much to litigate the issue, and it's better to just try to resolve it with the restaurant itself, and they'll almost always do that. And the reason for that is, in that particular kind of litigation, if there was some type of contamination of the food that was in a can, you have to go all the way back through the distributors to the source of the food, the packaging of the food, and you end up naming 6 or 7 different companies, and then you have to hire an expert to pursue that issue, because the expert has to determine what the source of the contamination was or the spoliation was. And they're very expensive kinds of cases to pursue. So it's like owning a gold mine. If it costs you $4 to get every $2 worth of gold out, it's not much value to you. But as far as the restaurant's concerned, they're concerned about the goodwill in the community. And they will almost always reimburse you for your medical expenses, probably give you some free meals, and of course reimburse you for those 2 days lost.
And sometimes that happens even with, like, I guess, dry cleaning, because you could, food, the waiter might spill something on you, but they do try to do the right thing, don't
Absolutely.
they? Yeah,
Absolutely.
Always good point there. Well, I know it's time now for us to get into our main topic, fighting the insurance companies, and Vic brought along an attorney pretty close to home.
Absolutely. With the double hitters with the NFL now, the late night shows, we're not going to bring on attorneys from other law firms. We're going to use our own counsel. We just don't know how late they're going to go, and we appreciate all of you for staying up to see us. But it's just something we have to deal with during the football season. And luckily enough, I have 2 great young trial lawyers who work with me and can really help you to better understand different aspects of the law. And tonight, brought on the right-hand person who basically keeps me and Reed straight, and is a great young trial lawyer, and that's Melissa Detchmendy. Melissa, can you tell our viewers what are the consequences to an insurance company if they don't pay a valid claim?
Well, Vic, that's basically what's called a bad faith claim, and what that means is there's a statute that's enacted that protects insurers, and when an insurance company isn't going to pay a claim that they should pay. And basically what would have to happen is you'd have to do a demand to the insurance company for your claim, and if they don't pay within 60 days, you're entitled to the value of that claim plus 50% of that claim, or $5,000, whichever is greater, and then also attorney fees. So that would be a situation that'd be real important to go talk to an attorney, have an attorney help you, because there's very specific things that have to be done when you do the demand to the insurance company.
Okay, well, we have our first question of the morning. Mike from Augusta joins us. How are you, Mike?
Hi, how you doing?
Oh, just fine, just fine. Well, we understand your insurance company mailed back your premium on your situation. Fill in a few of the details for us.
Yes, sir. I had insurance, and I had it for about 1.5 years it's commercial, on a op, and the content of my shop, which was $250,000 content, $27,000 for the building. It took forever, and finally they had me go to a testimony under oath, or statement under oath, kind of a deposition. And afterwards, they advised me that they returned my premium, the $2,100 that I had paid in, and said that they were not going to honor the claim because when I was given the application for insurance, that I wasn't truthful in prior claims, and what it had come down to was the agent that took the claim, or that took the initial application. She asked me if I had had any prior insurance before, and I said, "Are you referring to my business?" And she says, "Yeah. Have you ever insured this business before?" I said, "No. This is the first time I'm insuring my company. This company." And I had no prior insurance before that, and I had never had any losses on that business. But I had losses on a house fire back in July of 07.
Mike, let me try to answer that for you very, very quickly. This is something that we see abused in insurance litigation all the time. Where you have a theft loss, a fire loss, they want these examinations under oath. And then they send an attorney down, just like this ongoing litigation, and they may question you for 3 or 4 hours. And they look for any out that they can possibly hang their hat on. If you're properly prepared for that examination under oath, you will not have a problem getting your claim paid. But if you're not prepared, you're kind of in the situation now where you kind of stepped off the ledge, and you got to get a lawyer to pull you back up on the top high ground, so to speak, with regard to the claim. There are certain standards that apply to this kind of circumstance where it has to be a material misrepresentation. It has to be one which affects the extension of insurance on your behalf, and also it has to be a situation where they can clearly prove that the agent asked you about your prior personal claims versus prior business claims. So I think you should consult a trial lawyer right away and get some help before you really mess up.
This is a situation that happens a lot of times with these homeowners policies, where they're putting in the policy a statute of limitations that might be less than what you might think the statute of limitation is, and so it's real important you talk to somebody quick in that case.
Yeah, and they'll delay the claim, delay the payment of the claim, and get you outside of the time period they set in your contract. So you should really look in your contract, and it'll have a provision under the table of contents when to file a claim. And even though the statute of limitations on contracts is normally 6 years, they'll put a provision in there that says you have to file a claim within 1 year, and then string you out past that 1 year period. And that's when you're going to get a letter about probably 30 days before that time runs, letting you know they just denied the claim. And if you let the time run, the courts are going to enforce it. It's a terrible rule, but it's the rule that we all face.
The devil's in the details for sure. Well, we head over to South Carolina, an accidental death policy situation. Pat from Aiken joins us. Hello, Pat.
Hello.
Tell us, I guess, about your ex-husband. Passed away?
He had cancer, and nobody heard from him for a couple of days, and we went over to check on him, and we found him laying on the floor, and he had fell, and he had hit his head on his coffee table, and his face was bruised really bad, and we had him sent to the hospital, and he never came home from that. He went to Aiken and then went to university, and from there he went to a nursing home, and when he passed, they put down that he died from cancer, and he got pneumonia in the nursing home. But he never recovered from that fall, and he had an accidental policy on his home that if he died from an accidental fall or whatever, it would pay. And they're saying because they don't have it down that he died from the fall, they're not wanting to pay. But he never recovered from the fall, ever. I mean, he couldn't talk. He couldn't. He laid on the floor so long he couldn't move his arms or his legs, or couldn't feed himself or anything. So I was wondering, do we have a case? Can we go ahead against this insurance policy?
You want to take it, Melissa?
Sure. I think that in this situation, you would have to be able to show that the fall is what caused his death. And I think that is something that you can do. I definitely think you'd have to go talk to an attorney and see if you could get someone to help you on that claim.
A lot of times you can actually meet with the doctors who treated your husband, and then explain to him that the legal standard is different than a medical standard. A doctor who fills out a autopsy report or a coroner's inquest report or death certificate looks at it from a medical perspective, and the legal rules are very different. And if the fall substantially contributed to the onset of your husband's death, I believe that you would be able to file a claim, but you need to consult a South Carolina trial lawyer right away.
Well, very interesting questions so far on our topic, how to fight the insurance companies. If you'll stick around through the break, we're going to take more questions and discuss more at 803-442-4551. You're watching News 12 Law Call.
Firm Augusta attorney Vic Hawk, known as a tough courtroom fighter, helping injured people for more than 30 years, plus guest attorneys from across the CSRA. Your rights, your calls, live. News 12 Law Call.
Welcome back. These days, it seems like anytime something goes wrong, somebody wants to sue someone else for damages. So do injured folks have the right to sue? Tonight, personal injury attorney Reed Sanders explains in our legal brief.
People always have the right to sue, but whether they have a case isn't always a slam dunk. Not every injured plaintiff is entitled to recover damages for the injury he or she sustains. The plaintiff must establish that the defendant is legally liable for his or her injuries. Whether legal cause is established depends on the facts and circumstances of the particular case. If someone intentionally causes harm or knows that certain conduct makes it likely that harm will result, they will likely be liable for it. Other personal injury cases carry a looser concept of fault called negligence. If you knowingly or willfully choose to encounter a known hazard, the law holds that you have assumed the risk of the injury and therefore no one is liable. I'm attorney Reed Sanders of the Vic Hawk Law Firm. Back to you.
Thank you, Reed, and we are joined by Reed's colleagues, Melissa Detchmende to my right and the boss man Vic Hawk to my left. And we're continuing our conversation about insurance companies, and Faye from North Augusta joins us. Hello, Faye.
Hello.
Well, we understand you're fighting the insurance company kind of related to your kids, is that right?
Yes, sir, and I cashed my policies in last year, I think it was. And then they cheated me out of a bunch of money, and they said it was run out of date. And they sent one man out there, and I got some of them already done like that. But then they sent another man out there, and he got mad. He said, "I ain't coming back out here no more." And he said, "You let it run out." But I said, "I wanted it before it run out. I wasn't gonna pay no more on it, and I wanted to cash them in, and I supposed to get $2,000 and $3,000 or more on some of them, and I didn't get hardly enough $300 or either $500 on some of them."
Faye, were they term policies or whole life policies?
There was life policies. I was paying every month on them.
Yeah. If you had a whole life policy, it's going to build up cash value. It's not necessarily going to be all the premiums that you paid into the policy, but it will build up cash value. The only way to really know if they're cheating you out of the money is to look at the policies themselves and then determine what the factual situation is that applies to the policies. In other words, for a lawyer to help you to understand what the contract means under that insurance policy, and then letting you know whether or not you have a valid claim. And we would have to look at the contracts themselves before we could tell you. But if they didn't pay what you're entitled to, they would be subject to penalties and attorney's fees.
Well, Jane from Georgia is on the line with us. And good morning, Jane.
Good morning.
What is the question that you have for Melissa or Vic?
We've had insurance on our home with an insurance company for about 20 years. Didn't have any claims on it, and then all of a sudden we had about 4 claims in roughly a 2-year period. We were always advised that if anything happens to call immediately. So we had an upstairs bathroom that flooded and into a downstairs room. So I called them and told them that we may possibly have a claim. We were going to do a cleanup and see how things looked. We did the cleanup. There was no damage. called them back and told them we weren't going to file a claim, that there was no damage. They recorded it as a claim, even though they did not pay anything out. So when it came time to renew our policy, they would not renew the policy because we exceeded the claim amount. So now we can only get insurance with the Georgia liability or whatever, the state insurance that's so expensive. And I wondered if there was legal recourse for us to get them to remove that last claim that they have.
I think we see this a lot where you have insurance companies that are coming in and even though it's not considered a claim, then they're either raising the premiums or canceling it. Unfortunately, I think in a lot of these cases, they're private companies and they're allowed to decide who they insure. But there might be some legal recourse in certain situations. What do you think, Vic?
I think under the circumstances that you gave us, they have the right not to renew you. They would be obligated under the terms of the policy to provide coverage for those claims. The fact that they treated this as a claim, even though you didn't actually make the claim, is really just a corporate decision and reflective of the type of company that you're dealing with. And I certainly would avoid dealing with them in the future. But I don't know of any rule that would prevent them from doing that. Just like they could insure you or not insure you if you didn't have any prior claims at all. They could just say, we're not going to renew any more policies for your family, period.
Vic, do you think in a case like this it'd be helpful for someone like Jane to maybe call the insurance commissioner, just let him know what's going on?
Yeah, that's a really good idea, Neil. One of the things that our office does, and we're pretty lucky that one of the ladies that works for us is a former Geico adjuster and recognizes when adjusters overstep their bounds. And the first thing she does is file a claim with the insurance commission when an adjuster does something like that. And so I would suggest you contact the Georgia Insurance Commission, get their form, and file a claim explaining what's happened to you, and maybe you can get a better response from the insurance company.
And they actually respond. I mean, they respond pretty quickly and they really investigate those claims. So it's a good idea to do that.
Well, and it's an elected position, and
it's nice to be able to tweak them.
Yeah, good point indeed. Well, we want to give you our phone number again as we go to the break. You can call us if you'd like to fight the insurance companies. 803-442-4551. You're watching News 12 Law Call. Well, here's what's coming up on the program the next several weeks. On November the 11th, workers' comp. And the following week, we will roust Reed Sanders out at about midnight to do slip and fall on the program on the 18th. And then just after Thanksgiving, we'll talk about divorce and child custody. Well, we're so appreciative to Vic and Melissa for being on the program. You can reach them at any of their 4 offices. The main number to call to make an appointment, 706-722-3500. Chock full of good information at vichawklaw.com. And we want to get right back to the telephones, and we are joined by Gerald on the telephone. Gerald, are you there?
Yes, I'm here.
Okay. What comment would you like to make for Vic and Melissa?
Good morning, Gordon and Vic and Melissa.
Good morning.
Vic,
Good morning.
I deal with you for several years. You and your brother.
Well, good.
You might remember I'm Gerald. But I just want to say, as a matter of fact, I sit at that desk, 44155, for call for action.
Yeah.
So I want to say thank you and Melissa, and I thank you all for all your service, community service. And we appreciate it. I thought I met you all because I went to my brother-in-law funeral. I thought I met you for the night.
Gerald, thank you for watching. We really appreciate you and all the others like you that come up and talk to us out on the streets, in and outside the courtrooms and at our office. And we thanks very much that you take the time out to watch us and listen to what we have to say.
And I will say the best part about Vic, Melissa, and Reed is they're the same here at the desk as they are out in the community.
Yeah,
what you see is what you get.
That's right.
That's true. Well, we are pleased that Viola has stayed on the line for us through the program. Hello, Viola. How are you?
Hi, how are you all?
Oh, just fine. Hey, share with us, I guess, a paperwork dispute that you've been having with your insurance company.
I retained a hernia back in 1995, and I was told, my doctor told me to wait. I would know when to have the surgery, not to do it quickly. So I didn't have to have it until 2007, where it had gotten perforated and was real sore. So after I had the hernia removal, I obtained a blood clot. When I filled out my paperwork, the hernia did not cause the blood clot. I mean, the hernia didn't cause, the blood clot itself. I guess it was a surgery. So I'm not, they told me to put on the paperwork that it was the hernia, but it was really the blood clot that caused me to have 16 more surgeries.
Wow.
It got infected.
Oh.
So they wouldn't pay because they said I had the hernia before I actually took out the insurance. I mean, is they all in the same?
You want to try it, Melissa?
Well, I mean, are they saying that they're telling you it's a pre-existing condition? Is that what they're telling you?
That's right, because of the hernia didn't cause the blood. I mean, would it be where the hernia caused the blood clot?
Viola, that's really a medical question, but let me just tell you this. If you had the policy for that length of time, the pre-existing condition clause should have already been satisfied. So you're okay as far as that's concerned. I think what the problem that you have is the language that your medical provider is using in describing the cause of the blood clot. If you have a hernia and during the course of having the hernia you have a heart attack or you have a blood clot or some other condition, that is still a covered condition under your policy. And if you're having trouble getting that straightened out, you should consult a trial lawyer, present the valid claim in the valid form, and then they have to pay within 60 days or it'll be bad news for them.
Bad faith.
Bad faith.
Don't want that. No, that's for sure. Well, we sure do appreciate everyone staying up and joining us again on our program as we discussed insurance situations. And next Sunday night, we'll take questions if you happen to have been hurt on the job. Our job is done for this morning. We hope you make it a wonderful work week ahead.
Thank y'all for calling.